Hi, this is Jason, and I want to talk to you today about the two different types of wrongful death claims that can be brought in Washington and the major loophole that really needs to be fixed in our system. There are survivor claims and general wrongful death claims that can both be brought in a wrongful death case. Now, the general wrongful death claims are claims that the survivors of the decedent bring. So those are usually the beneficiaries of the decedent, which would include children, spouses, and under some conditions, parents. Now, the survivor claims is actually giving the person who has died their day in court. So essentially, through the survivor claim, you're allowed to claim the pre-death pain and suffering that the decedent suffered. It's as though the decedent lived through the trauma, whatever it was, and is bringing their own claim. It's just that in these particular cases, the decedent has actually expired because of the trauma. Now, the big loophole in our state is that general wrongful death claims cannot be brought by the parents of an adult child unless those parents are financially dependent on that child. So what that means basically is that if you are parents of a 17-year-old and that 17-year-old is the victim of a wrongful death, then you can bring a general wrongful death claim against the person that caused the death. However, the day that that child turns 18 years old, those parents no longer can bring a claim for the death of their child unless they are one of the rare cases that are financially dependent on their child in some manner. And courts have interpreted that language, financially dependent, in many different ways, so it's important that you speak with an experienced wrongful death lawyer if you believe that you're in the situation.